Good day, everyone, and welcome to another interesting class on Criminal Law 2, PUL342. I am your facilitator for this class. Dr. Akujobi Alera is my name. And today we shall continue our discussion from the previous time that we met on offenses against public order, against the state, and against public order. And the areas we shall be looking at today under topic 4 are unlawful assembly. We shall also be looking at AFRE, and also we shall be looking at arson. And of course, we shall have some questions we shall be discussing at the end of the topic. So as usual, it's another interesting time, and I enjoy you to participate in the class so that we can have a very fulfilling time together. Thank you. Good day, everyone, and welcome to another facilitation class on Criminal Law 2, PUL342. Today we are on to topic 4, and we shall continue with our offenses against public order. Today we shall be looking at unlawful assembly, arson, and even AFRE. I'm Dr. Akujobi Alero, your facilitator for this class. So what do we mean by unlawful assembly? Normally when we talk of unlawful assembly, both under the code and under the criminal code and penal code, they refer to offenses that are meant to prevent the breach of peace. These are, for instance, riots, AFRE, and when you see gathering of people, more than 3 or 4 in a particular place, and such gathering normally causing apprehension in people around them, or causing fear in people around them that these people or this group of people are likely to cause any chaos any moment. So such kind of gathering are normally referred to as unlawful assembly. The Nigerian position is patterned after the common law, where the said offenses and some other, e.g. riots, like I said, causing a breach of the peace and public nuisance, relate to preserving of public order. Such public order offenses are therefore created in order to combat conceivable situation of public order problems. This is like what I've just explained about, that when you see such gathering, normally it's being prevented in order to combat a possible outbreak of law and order. So the intent of this topic is at the end of the topic, you should be able to explain what unlawful assembly is, explain the acts that can fall under this kind of, that can cause such offenses, or that can lead to breach of the public peace. You should be able to identify the elements of each of the offenses we are talking about, like AFRE, what are the elements, arson, what are the elements, and things like that. And also you should be able to know the potential dangers posed by some of these offenses to the exercise of fundamental rights of the citizen. Like when we are talking about unlawful assembly, when and at what situation does it become, can it be classified as unlawful? And does one have the right at every given point to constitute an assembly? What are those things you must look out for? What are your constitutional rights in terms of this kind of an offense? So, under Section 69 of the Criminal Code, unlawful assembly code. Now, again, another thing we should take note again is that it does not necessarily have to be in a public place. Now, if 3 or more persons meet in a private place with intent to go out and commit acts that endanger public peace, it could also substitute as unlawful. It could also be taken as unlawful assembly. So, why is the essential ingredient in a charge of unlawful assembly is the gathering to disturb the public peace. The offense actually commences with that intent, with the intent to create apprehension, with the intent by their conduct and all of that, with intent to disturb the public peace. So it is necessary for us to have this in mind, that the presence of a person at a meeting is not in all cases illegal. In order to show that persons are unlawfully assembled, it must be proved that the persons intend to cause or abate the use of violence, and the use of violence in order to disturb the public peace. This was the position in the case of Oginyi and IGP. It's also important for us to note that the circumstance of every case will in most times determine whether the presence of people in a particular large number will constitute an unlawful assembly, such as the manner in which, like we said before, they carry themselves, the manner in which they sing some war songs, the manner in which they throw up all kinds of dangerous weapons, that, and then, or the way they carry their clubs and the kind of languages they use. All of this will determine whether it's and the case of IGP and all Nigerian People's Party, also the case of COP and Anambra and Attorney General of Anambra State. We also looked at Section 215 of the Constitution. Now, all the cases are all tending towards the point that yes, the governor of a state has right to ensure that everybody that wants to go into procession, gather together, do so in a lawful manner. At the same time, the cases are to the point that the issuing of a license, that the public or citizens no more need to get a license before they can carry out a peaceful procession. But like I said before, this is still subject to Section 45, subsection 1 of the Constitution. So it is enough for so like I said, that section, Section 41, subsection 1, permits any law that is reasonably justifiable in a democratic society in the interest of defense, public safety, public order. Of course, this has led the Court of Appeal to affirm the lawfulness of the Public Order Act in the case of Lewis Chukwuma and two others, and the Commissioner of Police. So we have seen that notwithstanding the above decision, it has been contended that it is only in emergency that the right to freely assemble can be restricted, and that the provisions of the Act, especially that of requiring people to seek and obtain license from the police before people can freely assemble, is antithetical to a democratic society, as it placed the lead on the exercise of a right guaranteed by the Nigerian Constitution. So this is still saying what we're saying, that notwithstanding that provision that it is subject to Section 45 arises only in emergency cases. So it is only in emergency case, for instance, where there's a breach of the peace, where there's chaos, where there's all kinds of riots, then of course that can be brought in order to, that the assembly can be restricted. So apart from that, the issue of seeking license from the police before people can freely gather is no longer seen as the position of the law, as Section 40 of the Constitution gives everybody the right to freedom of assemblies, freedom of procession. Again, in the case of IGP and ANPP, the Court of Appeal sitting in Abuja struck down the Public Order Act as impinging on the fundamental rights of the Constitution. This is another case too that is to the point. The court held that no individual or group of persons requires a police permit or approval to hold rallies and peaceful assembly. So this is definitely the position of the law in Nigeria as we speak, because if such is allowed, it will be in conflict with the provisions of Section 40 of the 1999 Constitution. Now, of course, the case of New Patriotic Party versus IGP in Ghana is also a case that nullified the Public Order Decree of 1972 of Ghana, requiring people to obtain police permit before embarking on public procession. So that's about unlawful assembly. So we've seen that there are certain things that you must look out for, where two or three or more persons are gathered together with intent to disturb the public peace, with by their conduct put fear or apprehension in their neighborhood and all of that. And where, for instance, by their conduct, like I said, they also carry out the manner of carrying out their procession, where it is fearful, where it's threatening, maybe with the use of weapon and all of that. Such assembly can be regarded as unlawful assembly. Now, what is riot? Riot, again, is another unlawful assembly which are generated into violence, involving acts of violence by one or more persons, which acts constitute a clear and present danger or shall result in damage or injury to the property of any other person or to the persons of any other individual or threat of all. So this is, for instance, riot can be said to be aggravated unlawful assembly. In other words, is you see people coming out with clear aim, clear aim of injuring people, killing people, destroying property, all of it, So that, and then you see everybody running head to scatter, closing up shop, doing this, that, because of the presence of such people. So again, this is a clear case of aggravated unlawful assembly, and it's provided for in section 71 of the Criminal Code and also section 106 of the Penal Code. Punishment for this, of course, is imprisonment of 3 years, with fine, with option of fine or with both. So section 71 of the Criminal Code and section 106 of the Penal Code, and then punishment of 3 years or with fine. Again, note that this is again a felony, you know. So that is about riot. So, like we said, it's a more serious form of unlawful assembly, and of course, because it's more serious form, the punishment is also more severe. So, um, what we have here is still talking about riots and where in Eyo and Eyo, the congregating of about 500 people who were armed with weapons on a public highway, singing and chanting and constituting obstruction to the public way, and refusing to leave when asked to do so by the police was held to be a riot. You know. Also, we've seen that the stripping and beating up of someone in a public place by other people who came together for that purpose was held to also constitute a riot in the case of Adebi and Inspector General of Police. So, it is important at this stage that you must be able to distinguish between the offense of unlawful assembly and riot, because the essential factor is that in the former, there need not be the actual use of violence, that is an unlawful assembly, but the causing of persons in the neighborhood to fear on reasonable ground that the assembly will eventually disturb the peace. While in the latter, if the use of actual violence or use of force. So that's about it for riots. Briefly, what do we mean by AFRE? AFRE is a public offense at common law. It is the mutual combat of two or more persons to the terror of the other. It differs from riot in that it is not premeditated. The fight does not necessarily have to be in a public place, does not necessarily have to be in a public place. What is essential is that the fight in the fight, there must be a fight, and that these are some of the ingredients or the elements. There must be a fight, and that this fight made members of the public to be terrified, made members of the neighborhood to be scared. It must also be established that members of the public had access at the time of the AFRE by rights, license, um, permission, conditionally or unconditionally. So, brief questions I have for you here is, for instance, to state what are the similarities between the offenses of riot and AFRE. What are the similarities to differences between the offenses of riot and AFRE? Then number two, what are the essential elements to be proved in the offense of unlawful assembly? What are the essential elements to be proved in the offense of unlawful assembly? Then again, a question here is, people numbering about 320 gathered at a public place to peacefully protest the planned total removal of petroleum subsidy by the federal government. The police swapped on them and arrested 50 of them on grounds that they are likely to cause a breach of public peace. You are to advise those arrested on the legality or otherwise of the police action. Advise those arrested on the legality or otherwise of the police action. So we will stop here today, so that when next we'll meet, we'll look at offenses against the administration of justice, wherein we shall be looking at the offenses of perjury, contempt, and like other offenses under it, even the offense of corruption. So do have a good day. Thank you.